With due respect to the trial judge, we do leave the court premises today with disillusionment in the way the matter has been handled. We are really disillusioned with the way the whole matter has been processed, because the writ of habeas corpus, which in simple terms is a prerogative order which can only be given by court in exceptional circumstances like this, where one's liberty has been curtailed without any justifiable or lawful cause, is a matter which has to be disposed of expeditiously. And when you look at the provisions of Article 23, read together with Article 44, this right to a habeas corpus is non-derogable. It comes into play in emergency situations like this, where one's liberty is curtailed and their life is in danger. So Dr. Besigye was brought together with Obed Rutare this morning under very, unreasonable circumstances. There was an order that he be returned to Ruzira without a valid remand warrant. Yes, we appreciate that court ought to have listened to all of us, both sides, before rendering a decision. But we made a good case for quick interventions, and we thought court would come up with the declaratory orders today about the legality of doctor's incarceration or the curtailment of his liberty. Unfortunately, it has not happened. Yes, we have made our submissions. We are grateful that the judge has listened to us, and we also appreciate the fact that he interrogated the circumstances under which Dr. Besigye and other prisoners of conscience are being detained in total violation of the Supreme Court order or directive. Unfortunately, we have not got a decision today. We are walking away from the court premises without a remedy today. So we expected a decision to be delivered today. It should be instant. And we brought out all the relevant authorities that would require that, honestly speaking, the justice of the case required that today there should be a remedy, there should be a decision, and it should be instant. Unfortunately, that is not the case. And to make matters worse, we have not been given any idea or clue as to when the decision will be given. We have been directed that tomorrow we write to the judge requesting for the date when the decision will be delivered. It's really baffling, because at least if he was not in position to give the judgment today, probably would have indicated that give me today or tomorrow, then I'll deliver the ruling within the course of tomorrow or the day after tomorrow. That was never to be the case. You see, you cannot again curtail one's liberty, which are duly guaranteed under the Constitution, the Bill of Rights, on account of the government ready tape, bureaucracy. You heard their flimsy arguments. The state, the Attorney General, they are saying they are exchanging communications. The letter to the principal judge, a letter to the Chief Justice, a letter to the CDF, a letter to the Attorney General, a letter to the DPP. They are just still exchanging communication. They are hiding under red tape, under bureaucracy, to continue violating the rights of Dr. Besigye and other prisoners of conscience. We thought the court would bring that to a halt, that would stop that kind of impunity. Unfortunately, it would appear court developed fit of Kire and had to delay the delivery of the judgment. So we are going to retreat and see the next course of action, how we shall get a remedy under the circumstances, as we await for the court decision in this matter. But we leave these premises with a heavy heart, with disillusionment, and of course devastation. That is it.
Put in black and white. This is not prosecution, this is persecution. Dr. Besigye would not be brought to court today if it was not for pressure. You notice this is the same judge that sent Kabwenza to prison instead of sending him to the ICU after grave torture. This is the same judge that said the cash bonanza parliament was legal. At the same time, this is the same judge that is sending Dr. Kizza Besigye back to prison instead of sending him to hospital. This is a cadre judge. This is a regime persecuting Dr. Besigye and all other political prisoners in the name of prosecution. My only call is to the people of Uganda here and abroad. The only thing that works with this regime is pressure. I want to thank all those in Kenya, in all of East Africa and all over the world that are putting up pressure. Please put up pressure. From here, we are going to hold prayers at Kabule for Dr. Kizza Besigye and other political prisoners. We are not going to stop. We gave the regime 48 hours to release Dr. Kizza Besigye because we want him alive. They are trying to kill him, and all of you see. So I call upon the nation, all people of goodwill, to stand with not only Dr. Kizza Besigye, but all political prisoners, especially those that are in prison illegally, courtesy of now the defunct military court. So stand with Dr. Kizza Besigye and all political prisoners, exert pressure, because pressure is the only thing that works under the dictatorial regime. Thank you very much.
Now, my lord, in this case, Dr. Kizza Besigye, or the applicants here, were arrested and charged with various criminal offences, including treason, my lord, which justifies their pre-trial detention under Ugandan law. The fact that this case was initially handled by the court-martial does not negate or does not invalidate that we had valid reasons, my lord, to detain them. And my lord, the Supreme Court, well aware of this, simply said, transfer them to the civil court. Our submission, my lord, is any argument about a warrant being not valid can only be made after the process of transfer has been completed, and this will happen before the criminal court, which is going to handle his matter. My lord, it is very misconceiving and misleading for this court handling a matter for habeas corpus to go into questioning the validity of the warrant, which is the basis for which the applicants are saying they are holding him illegally. My lord, that is not the purpose for habeas corpus. We are praying, my lord, that you be persuaded by this decision. And my lord, we have highlighted the relevant facts, and you will notice that the court said, the court actually said that you should not question, that the question then arises, what should be the proper approach by the court in determining any such inquiry it may make. Of course, the authority on which the Galoa holds the applicant is the authority of the court. The court-martial was a court at that time. Can only, and it is still a court, can only be to see whether the court, this is what this court says, can only be to see whether the court had facts before them entitling them to issue the authority, the warrant. This is what we are telling you, my lord, that we had valid reasons to detain the applicants. So to argue right now that the warrant is invalid is not proper before you, my lord.
Wind up.
And on that basis, my lord, we pray that this application is dismissed for being premature. We have clearly stated to you follow the affidavit of George Kalemera, the processes that the Attorney General has taken in compliance with the orders of the Supreme Court, not outside the orders of the Supreme Court. My Lord, we pray that you are persuaded by our submissions and dismiss this application with process.